As promised, John Rizvi is on the line with us this morning, and our conversation is brought to you by Marcus and Mack, voted best personal injury law firm in the Best of Indiana County contest. Marcus and Mack, a law firm representing injured people. John is the patent professor. He's an adjunct professor of patent law at Nova Southeastern Law School in Florida. By golly, IUP plays Nova Southeastern every now and again once you get into the NCAA basketball tournament. John, how are you today?
Yes, I'm good. It's always a pleasure to be here.
Well, I'm glad to talk with you here this morning. It's an interesting topic to me because we're right at the real beginning, I think, of the AI age, aren't we?
We are, and just when we think we've gotten things figured out in terms of intellectual property on patents and trademarks, something and copyright, something changes, and the tools that are used become more sophisticated. And that brings us back to square one again, and that's exactly what's happening with AI. It's really no different than in the 1800s when the photographer sought copyright protection for a photograph, and the Supreme Court was grappling with the question of whether the camera was the author or the human photographer was the author, because a picture, a photograph was a new form of art. And the court decided that the photographer had enough creativity with the background and the lighting and everything else that the camera was just a tool. And the same way a painter uses a paintbrush as a tool or a sculptor uses a chisel as a tool, the proponents of AI being entitled to intellectual property claim that AI is just a tool and the human being is the author or the inventor. The problem is AI is such an incredibly powerful tool. It's like no other tool authors and inventors have ever had in the past at their disposal. So the contribution from the tool or the robot or software is way, way greater than it's ever been. And the human contribution is significantly reduced. And that's what creates this conundrum, is at which point is the human contribution so small that they can no longer be seen as an inventor or an author. And if they're not, under the Constitution, intellectual property is only for humans. So if there's no human contribution that's significant enough, then there's no intellectual property protection for a robot or software-generated idea.
That's a great historical context for it all as well. And the difference, as you point out, is really the fact that we're only at the beginning of learning what AI will eventually be able to do. So we're assuming that even though the U.S. Patent and Trademark Office has made this ruling that only real people can patent inventions, that could change and that will be challenged, won't it?
It's, and in fact, President Biden issued an executive order at the end of October asking the Patent Office to provide guidance to inventors on how much contribution is considered a significant enough contribution. And unfortunately, the guidance provided by the Patent Office is that the human contribution has to be significant. And really no definition of when it is significant enough.
Yeah, well, that's a real problem. It's a definition of terms, number one, and then it's trying to fit those terms to the actual situation. So artificial intelligence is going to be something that actually creates things that humans might not have come up with, or certainly wouldn't have in as timely a manner. And so, who gets the credit? Therefore, in a very cynical way, you could say, who gets the money from the patent? And that's a really important discussion to have.
It is, and the one thing that's clear, I mean, there's not a lot of clarity here, but there is an inventor, Stephen Thaler, that filed for a patent and listed as the inventor instead of listing himself. He was and listed AI as the inventor, and the patent was denied. So we know if it's 100% AI developed idea that you are not entitled to patent protection. What we don't know is how much of a contribution from a human is considered to be enough. We don't have clarity yet on that point.
And as the patent professor, you can maybe explain to folks why that is an important discussion to have.
Yeah, so because, as of 2013, the U.S. has been on a first-to-file basis for patent protection, and whoever files the application earliest owns the idea and can prevent competitors from entering that market. So that's a huge advantage. It's going to help with getting investors to go in. But the problem is, as long as there's this fog over AI-created inventions, investors really don't know if their investment is protected from competition, because they're not sure if the inventor is entitled to intellectual property. Under the U.S. Constitution, it has to be a human author or inventor. If something's 100% created by software or a robot, there's no protection for the inventor, and therefore no real protection for the investors either.
People might not think that's a very important argument to have, or an important discussion at all, but it really is, because we're not talking about giant corporations with big labs as much as we're talking about guys that are working out in their garage or gals that are down in the basement, and they're coming up with something that nobody's thought of, and they would love to be rewarded for it.
They would, and what a lot of people don't realize is that, they may look at, okay, this is someone tinkering in their garage, but that's what Steve Jobs was, and the creator of Apple. That's what Jeff Bezos was. That's, in fact, Elon Musk. Who would have imagined that the first commercially viable electric vehicles would not come from Ford, GM, or Chrysler, and these companies with basically billions of dollars of taxpayer aid, but would come from an individual creator of PayPal. So the newest ideas, the world-changing ideas, more often than not, are coming from tiny startups and individual inventors, and not the large corporations. So it is critical to protect them and make sure that their ideas are protected, or else they don't have the incentive to go forward. And more importantly, the investors are not going to back an individual unless that individual can prove they have their IP protected, their intellectual property protected.
We're talking with John Rizvi, the patent professor. He's written 2 books on patents and their importance in America, and how important they are to men and women who are working on inventions and things of that nature. But John, this argument also ventures into areas that maybe we hadn't thought of. AI created music, AI created artwork, AI created books, and whether those things can be impacted by this.
Yeah, so it's a tough question, because the more sophisticated the AI tools become, the more sophisticated the detection devices become to detect when AI has been used. So certainly that's an issue. That's something that I'm an adjunct professor of law school, but all teachers and professors are grappling with this when you have papers submitted to determine whether it's really the student's work or if it's the student utilizing AI. And that's why, at least in the law school scenario, I'm leaning towards in-person exams with paper and pens, because that way at least I know that what I'm reading is the student's own work.
Isn't that interesting? Because we had a school board member who told us about this at the very beginning, that this was something that schools would have to grapple with. My son is a teacher. He deals with it. They had a student turn in a paper, and in the middle of the paper, the kid hadn't read it, but in the middle, the AI device or program actually admitted that it was AI. and so my son, he posted it on the door and highlighted that so people could see. But it's actually forcing people in the education business to go back to the way it used to be done.
Yeah, exactly. It's almost like, all that's old again is new. All that's new is old again, or whatever that is. It's we're seeing a repeat of tried and tested ways of ensuring that a work is done by the student, and that's there's no better way than to have them come into school in person, paper and pen, with a book or with a tablet, and that's where you write your examination questions in. And that's how we know that that it's your work and your original thoughts put together, and not something generated software.
Wouldn't it be interesting if we had to learn how to write again, John? It's an amazing thing, and we're going to watch it unfold before us over the course of more than just a few years. John, this is going to be something that really evolves, isn't it? Just as AI evolves.
It is, and it's it's kind of in all fields. I mean, you look at even safety devices that on cars, for example, rear view cameras and blind spot detection, and you look at the drivers that have learned with these devices in place, they're dangerous when you take these devices away, right? You get, they're not used to checking manually for blind spots, and everything's fine as long as the technology is working. But when your blind spot detector fizzles out and your rear view camera fizzles out and you have to back out of a parking space and you've never done that before using a real rear view mirror, all of a sudden there's a challenge. And that's the issue with students using AI. It's fine for test-taking purposes, but when you're in an environment where you don't have the ability to type something in and get an answer live in real time, then how do teachers develop that ability to put rational thoughts together in a coherent sentence? You can't use AI for that.
Yeah, my car has automatic high beam, low beam, and when I drive my wife's car, I automatically high beam people because I'm used to my car actually putting them down for me. That's exactly what you're talking about. John, thanks for the conversation today. That's been good.
It's always a pleasure. Thank you.
Have a great day.